I don't think you all understand who I am.
Her nickname's Drunky the Bear. We know they drank from sunup to sundown.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
It's her day to pick up the kid, but
okay.
It doesn't always happen. 1 or 2 days a week, maybe she gets them.
I excel at everything.
She hasn't worked for over 2 years. I mean, she was always calling to borrow money, and but it's been like 2 years since she got a job. She keeps on telling me she's looking, and she's always finding the good opportunities and everything, but...
Good Monday morning. Today is September the 16th, and we woke up to some more docket files uploaded to the Sarah Boone case, and I'd like to go over this. Just a reminder, her defense has until tomorrow. Tomorrow's the deadline to file any objections on evidence. So I'll stay up to date on that. Update on me really quickly. My uncle is going into surgery in the morning. They kept pushing it back and pushing it back. So I don't know what my day is going to look like tomorrow. I've tried to set up some pre-recorded stuff for you guys in the meantime. If I'm at the hospital and I can do a recording and get it up while we sit in the waiting room, I'll do that. So let's see. Let's get to this item. Right now, as I record this, it is 11:27 a.m. Central Standard Time. And as you'll see, the only thing here is the notice of intent that's new. Since I've discussed what's on the docket, there have been 2 more things filed. So let me just look at these really quickly. We've got Henderson. Tony L. Henderson has joined the defense. He has a very long history going back with James Owens. Everything that we've seen shows that they actually are really good friends outside of the courtroom. So that's all I'm going to say about that. And then we have a notice of filing. Comes now the state of Florida by and through the undersigned assistant state attorney and gives notice that the following listed exhibits have been disclosed to James Owens and Kevin T. Beck, who at the time were the only 2 defense attorneys on it. The following have been sent electronically on September 11th of 2024. Previous depositions transcripts. I was thinking about something earlier today. This came from the assistant state attorney, Dave Cacciatore. So here's what I was thinking about. The only thing that we have as far as depositions is what the defense has put out there. And that's through our docket dives, right? But the prosecution, we won't see theirs until trial. It looks like the next door neighbors, Vinny and Brandon, are going to be on the prosecution's witness list. They've got to be, you guys. Think about it. They heard the noises. They're the only witnesses, technically, other than Sarah, to any noise, visuals, anything that night that we're aware of. So they've got to be. Anyway, I just thought about that. I'd love to see what they're putting out there. But again, due to the media hype, the state has said nobody can get in there and look at the witness list anymore. So that sucks. Okay, so let's look at this amended notice of intent to rely on the defense battered spouse syndrome. Now, so first the defense came in and said, we're going to be using the battered spouse syndrome defense. And here's your notice of that. We're going to be calling in Dr. Harper and all the legal mumbo jumbo, right? Okay, then the state came back. There's 2 other videos connected to this video leading up to this document right here that we've done. If you want to go back and look, state came back and said, no, you can't use it was an accident defense. It was not intentional. And then also use the battered spouse syndrome defense. So now here we are with this document here. I'm going to read this document to you. Again, I'm not an attorney. I don't pretend to be an attorney, and I don't play one on TV. We might have Sam come up at a later time and go through this document with us. Okay, so comes now the defendant by and through the undersigned attorney pursuant to Rule 3.201 of the Florida Rules of Criminal Procedure hereby moves to amend previously filed notice to rely on said defense and states. On August 30th, 2024, a notice of appearance was filed in the above styled cause. On September 5th, 2024, expert Dr. Julie Harper met with the defendant at the Orange County Jail. Who wouldn't want to be a fly on the wall for that one? On September 6, 2024, the notice of intent to rely on the defense of battered spouse syndrome was timely filed. For, at that time, the defense provided the nature of the defense and witnesses insofar as possible. To date, additional information has been obtained through discovery and investigation efforts. Accordingly, the defense moves to amend the initial notice to proffer the additional information. So I get what they're saying, you know, and I think Judge Kranick is going to allow this attorney a little bit of leeway here as far as some of this. And the reason I say that is because he's fair. Kranick's fair. He wants her to get a proper defense so she doesn't get an appeal. They might need up until, you know, a day or two before the actual trial starts to get this stuff done because they just got on the case. All right. Battered women syndrome has been described as a condition wherein a woman who has had a long-standing personal relationship with a man in which she is frequently subjected to physical abuse remains with the man but eventually acts against him because of her fear that his continued abuse will mortally injure her. Mortally injure her. They reference Terry versus State, 1985 case. At the time of the alleged offense, the defendant was suffering from battered spouse syndrome. As a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, Jorge Torrez. Okay, actually, it's Jorge Torrez Jr., whoever wrote this at your office, Mr. Owens. Is it Owens who filed this? Owens or, yeah. I was going to say Beck might have filed it. Okay. In support thereof, the defense will present witness testimonial evidence, records, and pictures and video evidence to support its contention. This is where it's going to get good, you guys. I feel like this guy knows he doesn't have a leg to stand on with this. All right, I'll get to it. Hang on. Okay, let me just go forward. In particular, the evidence will demonstrate factors that trigger BWS, the physical symptoms experienced during BWS, the distinct behavior and psychological symptoms exhibited by the defendant that are consistent with a person who suffers from BWS, and the impact of BWS as it relates to the facts of this case. Well, what about BMS? Battered man syndrome. I think we got a case for that here. Prosecution. Okay, so again, they're reiterating that Dr. Harper is going to be the expert witness. She's a forensic psychologist, will be a Category A witness for the defense in establishing this condition on the behalf of the defendant. To date, Dr. Harper has met with and evaluated defendant on multiple occasions, and the visits date back as early as August 2020. You know what? The fact that he just wrote that there makes me think he's going to say, Judge, it shouldn't just happen that we're bringing in this witness. She's been on the case since this first happened, since Sarah was first suffering, you know, since Sarah first came into jail and she was suffering from this being beaten by this man. And the witnesses relevant to BWS defense include, this is where it gets freaking interesting, you guys. Okay, they've already said Dr. Julie Harper. Blah, blah, blah. Officer John Alden with the Orange County Sheriff's Office. Incident date 8/28/2019. Well, guess what? We got that. I just realized I haven't uploaded everything under the body cam footage. Hang on. You know how at the end of the video, you get the little pop-ups that say, watch this video next? Okay, I can only do 4 there at the end. So what I'm going to do is in the comments down below, I'm going to link all of the different videos that we've done that would pertain to this document that we're looking at right here. So if you guys want to go back and watch it, you can. It's double checked. I'm getting old, guys. My memory's going, but I just wanted to make sure that I hadn't missed anything. So the body cam footages that we have are from the summer. There's one in the summer of 2018. Then there's one in July of 2019. And then we have one in September of 2019. This body cam footage in August that he's talking about on the 29th of 2019 we have not seen. I have not seen it. If you guys, if it's out there, please tell me. Let me know. Please email me. Don't put it in the comments. Email me, please. Because I was wondering if that was going to be shown. And I was actually, I assumed that they would have body cam on when they responded to this incident. So I'm really interested to see what this looks like. Really super interested. Not to confuse you, but let's keep going down the witness list. Now, Officer Kenneth Davis with Orange County Sheriff's Office, he was one of the ones that came on September the 4th of 2019. That I just got that out there. I might be the only one on YouTube other than Court TV that has that video. That was the one where she had walked all the way down to Brian's house. It's less than a mile away. Barefoot, called the cops, and then the officer had to come meet her at Brian's house. She brings her son out to the officer's car so he can meet her. Then she gets in the car with the cops to go back to the apartment. And of course, they don't have a key. They can't get in. Anyway, go back and watch it. It's absolutely ridiculous. Okay, Officer Joseph O'Neill, Orange County Sheriff's Office, from the incident on June the 15th of 2019. Officer Patrick Strawn with the Orange County Sheriff's Office, incident date June 18th, 2019. I want to say it's the 15th that we don't have the body cam on. We have the body cam on the 18th of June. I'm so glad that they have those. Then they're talking about bringing Brian in on the defense's side. You know, guys, I'm going to tell you, if they've got him up in Gainesville now. Good for him. You know, that's good. If that's where he moved to, he's getting their son away from all this crap. Guys, if Brian ends up freaking on the stand in her defense, which it sounds like they're going to do, and he's pushing to help her with his testimony, I'm going to be so pissed at him. I mean, it's his own decision. I mean, you know, it's his business, not ours. But I feel like this is the chance. She's not up there for the death penalty. You know, I just think that this is his chance to get her out of their lives and let his son grow up with some kind of normalcy. All right. Next, it says, the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. So it sounds to me like the defense is still going through every single thing on her phone, which I guess that could take a while. It could take some time too to get medical records sometimes. I would think that they'd be willing to send somebody up to wherever they need to obtain those medical records from the doctor's offices to physically go pick that stuff up. The time is not on their side. I guess what they're trying to say here is that, you know, you can say this isn't going to work, or the state can say that we can't do this, but we're still in the process of trying to get our things together. And we're clapping back to say, please don't dismiss the battered spouse syndrome defense just yet, Judge Kramick. Which, I mean, you know, that makes complete sense that that's what they're going to do, you guys. They're just doing their job. Let me go back and look at one thing. I've just pulled up my notes from these past body cams that we did. There's the battery call on June the 15th is the one that we have. My notes state the following. George was arrested for battery. Sarah said she was beaten up on face, head, and legs and arms. George said he did not strike Sarah and she did not strike him. There was a $200 bond. Well, it was a $2,000 bond, but it was $200 paid out bond. And George's mom bailed him out on that. He was to have no contact with Sarah, and he was not to return to Sarah's apartment. Based on my notes from the police reports on June 19th, because of the arrest on the 18th, his bond was revoked. Robert Wesley was assigned his public defender. I'm surprised they revoked his past bond, and they did a bond with pretrial release conditions to modify it to no hostile contact. Why did they do that? Let me tell you why. On June 25th, 2019, days after the arrest, Sarah signed paperwork with the defense to decline to prosecute and wanted to remove the no contact order George was to reside at his mother's home. So on June 25th, 2019, Sarah goes to George's attorney, signs off that she's not going to cooperate with prosecution, and she doesn't want a no contact order. She wants them to amend that to no contact with hostile actions, I guess is the word to say. The stipulation still said, though, that George was to reside with his mom at her home. They had a court date on that on July the 2nd. And he had bonded out on the 16th or the 17th for the June 15th arrest, which is really freaking scary because then they're going to say that this Officer Strawn, they're going to bring him in and they're going to try to say that on June the 18th incident that George had come back to the house and was further abusing Sarah. Okay, that was my June 15th notes. Okay, so here's my June 18th notes. On the 18th, this is what's weird about this 18th call, right? There were 2 calls from Sarah. And the charges were, the first call had to do with credit card fraud. And this is the one where we said, she is just trying to get attention again. This isn't even worth it. But I'm thinking ahead and I'm speculating, keyword, speculating, that the defense is going to come back and see, yeah, see, she was trying everything, Judge. She was trying everything, Judge, to have the police come to the house and see what was going on so that she could get away from this man. On the first call, Sarah claimed that George took her credit card. And when they went to find him, they couldn't locate him. He wasn't at work. He wasn't at his mom's house. Maybe he was in the tent over in the next building over. I don't know. He literally was at one point. All right, the second call she made, hours later, verbal argument. That was what the dispatch said. George was arrested for violating his pretrial release conditions. He had a $1,500 bond. Okay, this is where they revoked the bond from the 15th incident. So you're talking, within that 3-day time span, there were 3 calls. Robert Wesley also handled it as George's attorney, court appointed, of course. And quick note, the forms on this arrest show that George weighed 120 pounds at the time. They had a pretrial on August the 8th. They had the trial scheduled for August the 19th through the 30th of 2019. The case was held in abeyance. Pretrial release revoked. Additional bond, $3,000. They kind of took all these charges and put them together, pretty much, is what happened. October the 18th, they had a hearing and Sarah attempted to modify the release conditions. This is, you guys, this is so important because she had her chance out. And James Owens is going to say, well, Judge, you know, what's happening here is that the psychological feature of all of this, blah, 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 is that she could not get away from him. She was still scared of him. No, she had a chance to keep him in jail. So that's not going to look pretty upon the defense. He was ordered to have batter's intervention courses, and Sarah did mention those in her interrogation at the police station. July 3rd, 2019, he bonded out. So he was in jail for 15 days. That's what it was. On September 4th, cops were called again. He was arrested again. And on September 9th, he was placed back in jail. And he did not get out until October the 18th. By the time all this was said and done, he had spent 62 days in jail altogether. Not consecutively, but altogether. The trial was set for November 2019, but on October the 18th, he pled no guilty and he paid fines. He had a year's worth of probations and he had like a payment plan for all the court fees and everything. Here's a question for Mr. Owens. Why aren't we going to do the July 25th arrest? Why? Why aren't we going to do that? Because Sarah was arrested during that one. Yes, sir, she was. So our elephant in the room is that July 25th, he was arrested. Yes, he was arrested again for battery, but so was Sarah. And they don't want to put that in. In my opinion, they have to know. You guys, they have to know that the prosecution's going to bring in the body cam from the July 25th incident. Because that was the summer of 2018, where the cops walk up and she's sitting on the, actually, you know, at first it looks very compelling. She's sitting on the steps out front. She does look like the battered spouse. It's the great picture for the battered spouse. But it ends up that after they go in and talk to George, they find out that she was grabbing at his neck, trying to strangle him, and while he was trying to go up the stairs. So he was trying to kick her off of him, and when he did, he kicked her in the eye. The incident actually had started at a bar when Sarah was asking another guy for a cigarette. Sarah claims that George became angry and jealous. George said he went upstairs to avoid Sarah when she grabbed his throat. He did have injuries from this incident. Both Sarah and George were arrested. Neither would provide written statements. They refused to testify against one another. George was charged with battery. Sarah was charged with aggravated battery by strangulation. George had special release conditions, no hostile contact with victim, random drug test, no alcohol, drugs, or weapons, and he had probation. However, on August the 23rd, 2018, the case was dropped by the prosecution because neither of the defendants would cooperate with the prosecution. Again, that's body cam footage we do have. All right, so let's talk about this August the 28th. They want to have Officer John Alden come up. Again, this is body cam we have not seen. So he was arrested on the 28th. He bonded out on the 30th. I don't know who bonded him out. They ended up revoking that bond, though, later after the September 4th incident. Oh, and he had bonded out on the 30th for $500. No, I take that back, $100. That was what was so crazy, that after all of this had happened on August the 28th, the judge only put a $500 bond in place. So they only had to pay $100 to get him out. If the judge had done what they were supposed to do and put a higher bond in there, maybe they can only max out bond on domestic. Casey, I need you to answer this question. There's got to be limits on what they can put up as far as the limit to how high they can go on the bond for something like this. But I would think when you have consecutive arrest, multiple arrests, that they can enforce a higher bond. I'd love to know that, if you don't mind, Casey. Okay, now that you're retired, you need to give us some information, girlfriend. All right, allowed to go back to the apartment to get his belongings with law enforcement present after that incident on the 30th of August, or August the 28th. On September the 23rd, the prosecutor stated that the case was not suitable for prosecution. The bond was released, the case was closed, but he was in jail from the September 4th event. I had always said, well, it seemed like the state attorney was kind of picking and choosing their battles. Okay, you got all these other ones. We don't need this one against him to keep him in jail. Sarah said on this one, too, again, she did not want to prosecute and testify. So their injuries were, Sarah had marks on her neck. She claimed George woke her up and started punching her. She threw George off the bed. George had redness in his left eye and seemed surprised to see officers arriving. He said he gets hit all the time, but would not call police. Okay, you want to bring that one in? Bring it in. I mean, I don't know. The body cam footage might be damning, but the fact that he said he gets hit all the time, but he would not call police is, to me, very telling. And I'm so glad that they're going to bring that in. I feel like this guy's doing this and the prosecution's sitting back going, okay, cool. Let's talk about it. Bring that piece in. We got lots of notes on that one. Well, I knew this was going to happen. As soon as I got through editing that first portion of that first document that they put on the docket, they uploaded 3 more pieces. So let me go ahead and touch on these real quick. Let me talk about the small items on the docket first. I'm going to present this here. Here they're just, once again, I guess because they filed that other clapback on going after that battered spouse syndrome, they've again uploaded her resume, her very lengthy resume. Let's put on there how many times she's testified for the defense. I'd like to see that on her resume. All right, then the next document that's actually shorter, before we get to the big dog, is the notice that they're taking depositions. And they're going to take the deposition of Dr. Julie Harper on Tuesday, October 1st.
Does anybody think it's odd that they're waiting that long to take the deposition? I mean, it could be that she's having to do her work with Sarah, you know, her patient, to get all her time in with Sarah first before she actually sits down with them and talks to them about what she's going to say and everything. But I also find it interesting that, you know, attorneys can be so sneaky in how they do things, and they wait to the last minute to get to slip it in there. So there's not a whole lot of time for the state to come back and say a whole lot. But the state still has plenty of time to say anything after the deposition is received. All right, let's go over to this big dog that just came up on the docket. Defense response to state's motion to strike the defendant's notice of intent to rely on the defense of battered spouse syndrome. So this is in addition to their argument that they should allow this in. Comes now the defendant by and through the undersigned attorney and files defendant's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome and alleges as follows. Defendant's notice is legally sufficient. In a previous case, I'm not going to go through all this, amended through August 29, 2024, specifically recognizes the defense of battered spouse syndrome. Battered spouse syndrome is synonymous with battered women syndrome, which is recognized as a subcategory of post-traumatic stress syndrome by the DSM-5. The rule requires the defendant to give notice of the intent to rely on the defense no later than 30 days before trial. At the hearing before the Honorable Court, wherein the defense sought a continuance, expressly noting the recent efforts to identify, vet, and pursue expert testimony on behalf of the defendant, Assistant State Attorney Dave Cacciatore Jr. expressly advised the court before any specific affirmative defense had been raised that not only would the state not be prejudiced by the assertion of battered women syndrome, that it already was prepared for by the possibility of the said defense and had an expert witness that it intended to rely upon to counter any possible assertion of the battered women syndrome. As a result of this position, the state objected to the defense's request to continue the case. He's right. They did say that. Yeah, again, I'm not an attorney. Please don't. Just take what I'm reading here and in my opinion with a grain of salt. You want an attorney's opinion, go watch an attorney. And I know y'all go watch him. I know who y'all go watch. Y'all go watch Peter and then y'all come back over here. That's okay. That's okay. All right. The defense of intent to rely on battered spouse syndrome was timely filed by the defense on September the 6th of 2024. The notice of intent recognized Dr. Julie Harper as its expert as required by the rule. Dr. Harper's address was also provided as necessary. Other witnesses and their addresses have not been identified. However, the violent nature of the relationship between the defendant, Sarah Boone, and the alleged victim, Jorge Torrez, again, they left out Junior. See, it's typical defense, not paying attention to the victim, was raised by the defendant as early as the interrogation conducted by the homicide detectives the day following Torres's death, as she repeatedly asked the detectives to return her phone to demonstrate prior episodes of violence against her by Mr. Torrez. Numerous documents and records produced by the state in the instant matter support the possibility, if not the likelihood, of the defendant having suffered from battered women's syndrome. To the extent the rule recognizes the possible limitations on defendants' ability to identify all the witnesses, addresses, and specific nature of their testimony in support of the defense has complied, and the particulars of those supporting events have been apparent to the state, law enforcement, and any entity that has investigated the matter. It is apparent that not only was the state on notice of the likely reliance on the battered women's syndrome, it was prepared to respond and neither surprised nor prejudiced by the defendant's notice of intent to rely on battered women's syndrome defense, i.e., you sure did come back really quick. That's true. The state did come back really quick with their little thing. Okay. Further, defendant's notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in Rule 3.201. Given the current circumstances of the case, again, more rules, contemplate situations in which the defense is unable to provide a detailed statement of particulars in the notice of intent to rely on the defense of battered spouse syndrome, provides in pertinent part. The notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome insofar as possible. I wonder if they're going to go back and say, we didn't have that 30 days. And because we didn't have that 30 days, you have to accept that. Can they do that? I don't know. The undersigned is unaware of any Florida cases applying this language to a specific case. However, a plain reading of the rule implies that the court has the discretion to determine that the defense did not have sufficient time to provide a statement of particulars. Here, as noted previously, counsel for the defendant had insufficient time to uncover the full nature of the defense and the names and addresses of all the witnesses expected to testify. See, I said it before I even read it. Okay. Thus, the defendant's notice of intent to rely on the defense of battered spouse syndrome complied with the notice requirements found under Rule 3.2.01, given the circumstances. Okay. Roman numeral 2, the state's reliance on Medina and Hickson is misplaced. Really? Okay, well, let's hear what they have to say about this. The state's reliance on Medina and Hickson to preclude reference to battered spouse syndrome and Dr. Julie Harper's testimony is premature. In Medina, the defendant sought to introduce expert testimony during the trial regarding battered spouse syndrome without predicating it on facts already in evidence. Then they mentioned the Medina versus State case, which I'm sure our Florida private investigator Sam is already on this and checking into this for us, and we are going to do a video. Yes, yes, yes. I know we keep saying that, but we are. The court affirmed the trial's court decision to exclude the proffered expert testimony because the expert relied on inadmissible hearsay evidence. In this case, the state is attempting to use Medina to strike and limit reference to battered spouse syndrome in a pretrial motion. However, the defendant has not had the opportunity to lay the foundation for Dr. Julie Harper to testify, mainly because the trial begins on October the 7th. Therefore, at the stage of the proceeding, Medina and Hickson did not preclude reference to battered spouse syndrome and Dr. Harper's testimony. The state is improperly extending the reasoning in Medina and Hickson to Rule 3.201. Medina did not hold that insufficient notice under 3.201 precludes the defendant from utilizing or referencing the defense. The court in Medina does not cite Rule 3.201 or state whether the defendant sufficiently listed a statement of particulars. The court only considers the defendant's failure to present evidence of abuse before the expert's testimony. Furthermore, the state's position mistakenly assumes that Rule 3.201, Statement of Particulars, must list witnesses expected to testify to the battered spouse syndrome defense at trial. As noted earlier, Rule 3.201 gives the court discretion to determine what is legally sufficient notice given the circumstances. Specifically, the same rule states that the defendant must list the witnesses expected to testify insofar as possible. The state's view of Medina and Hickson would preclude a defendant from presenting the battered spouse syndrome defense when it is impossible to provide a list of witnesses expected to testify to the defense. Therefore, Medina and Hickson do not preclude the defendant from referencing battered spouse syndrome in her opening statement, nor does it preclude Dr. Julie Harper from testifying prior to the defendant testifying. See, before earlier they were saying, you can't bring in Dr. Harper to testify that Sarah was going through this unless you first have Sarah come up on the stand and talk about how she was going through it. So maybe they're trying to keep her off the stand. It should also be noted that the defense has moved for a statement of particulars regarding the state's theory of prosecution to which the state has objected. Wherefore, the defendant, Sarah Boone, respectfully moves this honorable court to deny the state's motion to strike, the state's motion in limine, and the state's motion for examination by a state expert. They should still be able to have a state's expert. And again, that was filed by the infamous James Owens. All right, before I end this, let me check. Make sure there's nothing else that's been uploaded since I just read all of that. Got that. Got that. Notice of intent. Did we look at that one yet? We got it. Okay.
Whew, you guys, it's getting good. We're getting close to trial. And on Thursday, we have a hearing where we're going to discuss this further. We don't have to wait that long to figure out what the judge is going to say about all this. I have the live stream already set up on my channel. So please make sure you go ahead and click that to be notified when we go live. I'm probably going to go live about 30 minutes early see, what time is the hearing? The hearing on Thursday is at noon Central Standard Time, which means it's 1 p.m. Eastern Standard Time. I'm going to go on 30 minutes early so we can talk about the case a little bit. So I will see you guys on Thursday on the live stream. If anything hits the docket between then and now, be sure to know that I will get it up there for you guys so we can be ready for Thursday. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.